So today, we are jumping right into a really fascinating collision of cases for this deep dive. We have Israel Claustro on one side.
Right, the sitting Superior Court judge in Orange County.
Exactly, caught running this illegal medical scheme on the side. And then on the other side, we have a stack of recent court rulings. I mean, specifically Dubin v. United States and United States v. Motley.
Which basically completely rewrite the rules for a white-collar defense. It really is a perfect storm, you know. You have a judge facing federal charges right as the Supreme Court changes the tune on how we define fraud.
And so that is our mission for you today. We need to figure out if these new rulings act as a get-out-of-jail-free card for Judge Claustro, because they drastically narrow the definition of identity theft.
They do.
I was reading through the Ninth Circuit's decision in the Motley case, and honestly, at first glance, it looks like a massive loophole just opened up.
It certainly looks that way. But to understand why, we actually have to talk about the hammer. So for years, prosecutors used a statute called aggravated identity theft. That is 18 U.S.C. section 1028A for the legal eagles out there.
Right. It was a favorite tool because it adds a mandatory 2-year prison sentence to whatever else you did.
Exactly.
Basically, if you use someone's name on a fraudulent form, they hit you with the hammer. But the Dubin ruling took that hammer away, didn't it?
Well, it essentially replaced the hammer with a scalpel. The Supreme Court introduced the crux test. They basically said, look, just because a name was on a piece of paper doesn't make it identity theft. For that extra prison time to stick, the misuse of the name has to be the crux of the crime, the very heart of it.
And the sources distinguish this as who versus how.
Exactly. A who deception is when I pretend to be you to steal your money. That is actual identity theft. A how deception is when I am who I say I am, but I lie about how or when I performed a service.
Which brings us to Tamara Yvonne Motley. This case is just wild. It is a $13 million Medicare fraud. She put the business in her mom's name and her nephew's name. Under the old rules, that is slam dunk identity theft.
Right, but the Ninth Circuit vacated that sentence. Because of that crux test we just mentioned. Motley had permission to use those names. Her crime wasn't who ran the company. Her crime was billing for unnecessary medical equipment.
So the court said the names were just ancillary to the fraud.
Exactly. It was a how crime, not a who crime.
Okay, so Motley gets off on the technicality because the identity part wasn't the main event. Now let's apply this to our judge, Israel Claustro. He is running a medical corporation illegally because he's not a doctor.
Right. He owned Liberty Medical Group.
And he has a physician, Dr. Kevin Doe, who is suspended from the workers' comp system. So Claustro takes Dr. Doe's reports and swaps in the names of other authorized doctors to get paid by the Subsequent Injuries Benefits Trust Fund.
He is literally swapping identities to bypass a suspension.
But wait. If Motley used her mom's name and got off, couldn't Claustro argue, hey, I just used these other doctors' names to bill for work that was actually done? Is that a Shen deception?
That is the million-dollar question. But Claustro has two massive problems that Motley didn't have. The first is simply the charge itself.
Right. I noticed Claustro pleaded guilty to mail fraud, not aggravated identity theft.
Precision really matters here. Dubin and Motley specifically narrow the identity theft statute. They don't touch mail fraud at all. Mail fraud is the workhorse of federal law. It is broad and incredibly difficult to wiggle out of.
So the crux test literally doesn't apply to the statute he pleaded to.
Not at all.
But let's play devil's advocate for a second. Say prosecutors had charged him with identity theft. Would he have walked then?
I seriously note it. Think about the who versus how distinction again. In Motley's case, the lie was about medical necessity.
The equipment.
Yes. In Claustro's case, the lie was explicitly about the provider. He was hiding a suspended doctor. The only way he gets paid is by pretending Dr. Doe is someone else.
So that makes the identity swap the crux of the crime.
Exactly. Unlike Motley, where the name was just paperwork, for Claustro, the name was the scam itself. It is a core who deception.
Meaning his path to exoneration is legally non-existent. He already resigned and pleaded guilty, and that plea is going to stand.
Precisely. The nature of his fraud differs qualitatively from Motley.
It's interesting, though, because prosecutors aren't blind. If the Supreme Court keeps narrowing these specific charges like identity theft to dodge appeals, won't prosecutors just stop using them?
That is the bigger takeaway here for sure. We are likely going to see a shift back to broad, unassailable statutes like mail fraud to secure convictions against figures like Claustro. It's just harder to appeal a mail fraud conviction because the definition is so wide.
So in an attempt to narrow the law, the Supreme Court might have just forced prosecutors to use blunter instruments.
The tools change, but the goal of locking people up remains the exact same.
That is a sobering thought to leave you with today. We often cheer when rights are expanded or laws are narrowed, but if it just pushes the justice system to use broader, vaguer laws like mail fraud to ensure high-profile targets don't slip through the cracks, are we actually better off? Definitely something for you to think about as you go about your day. Thanks for joining us for this deep dive.